Hello, this is Professor Guerra Pujol from the University of Central Florida, and welcome again to Legal and Ethical Environment of Business. In this next video on trademark law, I want to compare and contrast registered trademarks with so-called unregistered trademarks. We'll see that trademarks initially originated in the common law to protect the identity of goods and services. And then we'll see how you get trademark protection, whether you go with registration or just an unregistered common law trademark. Now, to give you an example, I've shown you the Coke bottle with the, if you look closely, the R, the registered R symbol. And one of the interesting things is, I love Starbucks, I love espresso. And don't get me wrong, by the way, I love independent coffee shops as well. But I love going to, let's say the Starbucks on campus. And you'll see here TM as opposed to the registered, the R with the circle. And the basic idea is, look, a trademark is a trademark. A mark is a mark. But the R in the circle represents a registered trademark, a federally registered trademark with the U.S. Trademark and Patent Office. Whereas a TM represents sort of an unregistered common law trademark. And this is an important idea. Like copyright, you get the rights to your intellectual property the moment you create a copyright, or in the case of trademarks, the moment you start using your mark, whether it's a trademark or a service mark, once you start using your mark in commerce, once you start selling goods or providing service with your logo, your symbol, your word, your design, whatever. And that's really, really important. In fact, even for federal registration, federal law requires that you actually be using your mark in commerce, or that you plan to do so within 6 months if you want to file a little bit early. So use is the important thing. The main difference between a registered and unregistered trademark is the scope of protection. Once you register your mark, you have nationwide protection in the U.S. You go to any federal court in order to enforce your trademark, to prevent anybody else, a counterfeiter, for example, or somebody else who's palming off or pretending to be provide your goods and services. You can sue them and get an injunction in federal court to stop that infringement. With an unregistered trademark, you have legal rights, but it's based on common law and only in those places where you're doing business, where you're actually using the mark. So registration gives you this presumption of ownership. Whoever registered is presumed the owner of the mark, and then they have nationwide protection, and they can get a federal court to issue an injunction. But whether we're dealing with a unregistered trademark in a local market or a federally registered trademark nationwide, the requirements to get a trademark, to protect your brand, so to speak, your mark, are the same. Ideally, the mark needs to be distinct. It needs to be really unique, although the law courts use the word distinct. And what the courts have done, beginning with the common law and incorporating into the federal law and the federal cases interpreting the federal trademark law, they've created sort of a gradation or a spectrum of different types of marks. And the idea is that the more distinct, to use the legal language, the more arbitrary or fanciful, those are the categories, the more arbitrary or fanciful your design, logo, or symbol is, the more likely it's going to get trademark protection. A great example of an arbitrary or fanciful mark would be the Apple logo, right, to describe computers as opposed to produce or fruits. Or think of the word Google, which is a play on words of a mathematical concept, also pronounced Google, but spelled differently, meaning it's a very large number. Think like 100 billion, something like that. The word Google to describe an internet search engine, right? That's very arbitrary and fanciful. That's going to get protection under trademark law, whether it's registered or unregistered. Another type of mark would be the so-called suggestive mark. This would be something like the copper tan, suntan lotion, or tender vittles for cat food, where you're not exactly naming, describing the product that you're selling or the service you're providing, but you're suggesting it. And generally, suggestive marks also receive trademark protection. Now, the next category are so-called descriptive marks. And I like to think like Facebook is actually a descriptive mark, since colleges actually had Facebooks, of course, in print form and non-interactive before Zuckerberg launched the Facebook. But I will tell you this, a descriptive mark is entitled to trademark protection if the owner of the mark, or would-be owner of the mark, can prove that there is a secondary meaning. That's the key term, secondary meaning in the minds of consumers. Think of, for example, Facebook today. Facebook today, clearly consumers are thinking not about the old college Facebooks that were printed out. They were like yearbooks, but they were given out at the beginning of the academic year. No, they think about the social network. They think about Mark Zuckerberg's website. Think of another good example would be American Airlines. American Airlines is a U.S. company, right? Serving the U.S. market and international locations as well. But it's descriptive. When I say American Airlines, you probably conjure up the actual, airline company, the two A's with the eagle, for example. Now, the last type of trademark would be the generic mark, and these are never protected, even if there's a secondary meaning, etc. Generic marks are never protected. They're just words to describe the product itself. Think of like a generic term like food mart to describe a little store. I don't think you could really protect that unless there would be a secondary meaning there. If it's just generic and not descriptive with a secondary meaning, it's not going to be protected. The most fascinating thing about trademark, and we'll end on this, is that a very famous mark can, through overuse, end up becoming generic. It's one of the ironies here of a trademark law and of being maybe too successful. This is a problem that Google now has to be concerned about, since we use the word Google as a noun and a verb interchangeably to describe internet search generally. Examples of formerly trademarked words that have become generic would be the term Kleenex to describe tissue, tissues for your nose, or Frisbee to describe, the flying saucers that you play on the quad or on the courtyard. So it has happened, it can happen. If you go and look at the term genericide in Wikipedia, you'll see a whole bunch of examples of terms that, although they began to be arbitrary and fanciful, they're now so closely associated with the actual products they're describing that they become generic. And so this is something that companies have to try to police to prevent that from happening. On the other hand, you could say if your term becomes generic, you have nothing to worry about. It means that's just how successful your product has become. So there are different schools of thought there, but I'm just giving you the law. All right. Well, we've done trademarks. We've seen the different levels of protection, different types of trademark, I should say the spectrum of trademarks. We see it needs to be distinct. We've seen what a trademark is. In our next set of videos, we'll look at trade secret law and trade secrets. Thank you for your attention, and go Knights.